The High Court decision in R Company AA vs. Secretary of State for the Home Department 2025 EWHC 1274 admin is a significant ruling concerning procedural fairness in the context of immigration sponsorship. It considers the extent to which the Home Office must observe principles of natural justice before revoking a sponsor license. This essay outlines the facts of the case, the legal arguments presented, the court's decision, and its wider implications for public law and immigration policy. Company A, the claimant in this case, operated a petrol station and convenience store. The company was granted a sponsor license under the skilled worker route on the 27th of September 2022. Its director, referred to here as Mr. X, was also designated as the Level 1 user, meaning he had primary responsibility for managing the sponsor license. On the 15th of November 2023, Mr. X issued a certificate of sponsorship to an individual referred to as Mr. Y, to fill the role of a petrol station manager. However, Mr. X failed to declare that Mr. Y was his brother-in-law, an omission contrary to Home Office guidance which requires such relationships to be disclosed to ensure transparency and avoid potential abuse of the sponsorship system. On the 6th of March 2024, without issuing any warning or affording the company an opportunity to respond, the Home Office revoked the sponsor license. The reasons cited were twofold: the non-disclosure of the family connection and the suspicion that the job was created solely to facilitate Mr. Y's entry into the United Kingdom. Company A sought judicial review of the Home Office's decision. The central argument was that the revocation was procedurally unfair. The company argued it should have been given an opportunity to make representations before the license was revoked, particularly because the revocation had severe implications for its business operations and its ability to employ skilled migrant workers. In support of its case, the claimant cited several key legal authorities including New London College v. Secretary of State for the Home Department, which affirms the importance of fair administrative procedures. Additionally, the company relied on another case law, where the Court of Appeal held that decisions based on allegations of dishonesty must adhere strictly to procedural fairness, including providing a chance to rebut such allegations. Mrs. Justice Hill found in favor of Company A. The court held that the Home Office's decision to revoke the license without any form of prior notification or opportunity to respond constituted a breach of procedural fairness. Although the Home Office argued that the relevant guidance permitted revocation without notice, the court reiterated that common law principles of fairness must still apply, particularly when the decision has serious adverse consequences. The judge also rejected the Secretary of State's attempt to distinguish the case from Balajagari on the grounds that no dishonesty was alleged. The court held that the principles in Balajagari extend beyond dishonesty to encompass broader questions of fairness in administrative decision-making. This judgment serves as a reminder that administrative convenience cannot override the fundamental right to a fair process. While the Home Office's guidance allows for license revocation without notice, this case demonstrates that such discretion must be exercised in a manner consistent with natural justice. The ruling affirms that sponsor license holders, even when accused of technical breaches, must be given an opportunity to respond before facing serious sanctions. For immigration law practitioners, it strengthens the argument that procedural safeguards are not merely formalities but essential components of lawful decision-making. R Company A is a landmark case that reinforces the role of judicial review in holding public authorities accountable. It upholds the enduring principle that fairness must permeate all administrative processes, especially where livelihoods and immigration status are at stake. Going forward, the decision may prompt the Home Office to revisit its internal procedures and ensure that affected parties are given the opportunity to be heard before punitive action